Hello and welcome to today's Appropriate and Defensible 504 System training. Today's training, as always, is brought to you by AWB Education. I'm your host, Adam Bush, and today I will be focusing on key points for administrators and 504 plan managers in a public school setting. This is a reminder from AWB Education that I am not an attorney. I am here to provide you consulting from a coaching lens, not legal advice. However, our coaching comes from years of experience in applying these practices in the daily lives of educators. We are doing this work alongside you, which gives you the practical application instead of just legal advice. However, if you ever have any questions that you are uncomfortable with, I would always recommend you consult with your district's attorney. Today we're going to talk about the differences between the two laws that are typically referenced when we are discussing Section 504. Those two include IDEA, which gives us the rules and regulations around special education, along with ADA, or the Americans with Disabilities Act, where Section 504 can be found. We will also discuss the requirements of child find and determining eligibility, and at the end I will talk about the importance of accommodations in a 504 plan being appropriate and therefore defensible. So why are we here? Well, we actually have a relatively small number of students that have 504 plans in our buildings compared to what OSTR estimates the number of students that would qualify under ADA. Now, you may be saying to me, no, that's ridiculous. I've got tons of 504 plans in my building. Although it may feel like that, if you actually look at the number that they say would qualify under 504, we probably still are missing kids within child find. And that is a requirement for us. Child find is actually listed within ADA, although we typically think about it within special education, but it is a requirement for Section 504 as well. You probably also, though, have started to see a little bit more of an interest in 504 from parents and families, and those interests are going to continue to grow. We're also seeing some growth in civil litigation, and we'll talk a little bit about the impacts of that from a court standpoint a little bit later on in our presentation. However, the fact is that we are seeing more and more cases every day. And so it's very important for us to make sure that we are doing things appropriately. Now, there are a lot of misconceptions when it comes to Section 504 and ADA, and here are just a few that I have heard over the past few years. Now, I've heard it actually stated, well, it's too late in the year to explore a 504. That came on April 3rd. You will have to wait until next year. That is not true. There is not a deadline. In fact, we are obligated regardless of what time of year it is or how many days are left of school. I also hear that you have to fail the evaluation for an IEP before you can get a 504, or one that's very common. The doctor said you have to have a 504, or they even sent a prescription for a 504, so the school must give you one. Or also that everything in a 504 in high school automatically carries over to college. All of these statements are incorrect, but they're very common misconceptions when it comes to 504, and frequently we need to help our families understand what's actually in the law and how this applies to them. Now let's actually talk about the two laws that we're discussing here. So we have Section 504, the Rehabilitation Act, which is actually where this started, where our United States government defined handicapped persons and the provisions within the law that people defined as that were allowed. This is where the Americans with Disabilities Act comes from, and it has been revisited a couple times, most recently in 2008, where some more of our guidance and expectations have come from. Then, of course, there's the Individuals with Disabilities Education Act, or IDEA. IDEA, or special ed law, is the one that we most frequently refer to because it's very extensive. There's a lot within that law, and it's a little bit more difficult to follow versus Section 504, as you're going to hear about within our presentation. There just isn't as much guidance, and most of the guidance within Section 504 is really just based on case law. It's just based on interpretation from the Office of Civil Rights. So let's talk about Section 504. So here's the exact wording from the Rehabilitation Act itself. It says, Section 504 prohibits discrimination against handicapped persons, including both students and staff members, by school districts receiving federal financial assistance. That's the key part there, that federal financial assistance. Almost every single public institution is going to receive this at some point in time, through some sort of fund. So that's why Section 504, or ADA, basically applies to anything remotely related to a public entity. So then within there, the Department of Education regulations for Section 504, that is the requirement that handicapped students be provided with a free and appropriate public education, or FAPE. And you will hear me talk about that frequently throughout this presentation. So ADA comes along, and it is modeled after Section 504. So 504, it specifically mentions institutions that receive federal funding, and this provided some opportunity for confusion, we will say, on whether or not this really applies to all institutions. So ADA comes along, and it identifies that virtually every entity except churches and some private clubs fall under ADA and the regulations within. Now, within those regulations, Title II specifically is what applies to all public and private schools, with some exemptions for some private and religious schools. But it requires educational opportunities, extracurricular activities, and facilities, making sure that these are open and accessible to all students. And that's the key. Do students have access? We're going to talk a lot about accessing a free and appropriate public education, which is required under ADA. Now, we commonly refer to these as 504 plans, but honestly, ADA is what defines the regulations within education and within the Section 504 law. And so really we should call these the ADA plans, because this is what meets the requirements within the Americans with Disabilities Act. But of course, we refer to these as 504 plans. Now, here's our first true and false question within our presentation today. So, IEPs, also known as IDEA plans, and 504s, ADA plans, these are the same plans with different names. Well, of course,